Hey guys, it's Dave Stouse, partner at Husch, Blackwell, and co-chair of the Privacy and Cybersecurity Practice Group here. I'd like to thank you for attending today's program on something new, the Virginia Consumer Data Protection Act. We're going to dig into a lot, but first I want to kind of answer some general questions for you. Before I do, there is a QR code that will take you to my LinkedIn bio. If you are not already LinkedIn friends with me, suggest you send me an invite. That way we can kind of track each other and what we're up to. We push out a lot of content on the blog and also on LinkedIn as well. So anyway, just a good idea for kind of keeping track of these types of topics in between webinars and blog posts. So as you can see with the speakers today, I am flying solo. No Malia, no Shelby. I was not able to wrap up a ringer from the IEPP like I did last time with Sarah Rippey. So just me. We have, typical ground rules, right, that we talk about at the beginning of every webinar. One of which is if you have questions, feel free to ask them. We'll do our best to answer. I think that is particularly appropriate today, given that I am flying solo. It will be difficult for me to read your questions at the same time as I'm talking. So feel free to ask them. We'll try to get to them if possible. There's a lot to unpack here today. But if not, I can try to get you answers potentially afterwards. And feel free to shoot me an email if it's something really kind of burning, a real question that you have that you really want to get answered. Just feel free to shoot me an email. My email address is on the page right there. What I will say is, as you know, I like to start all of my webinars with a roadmap. This is an obnoxiously long roadmap. Don't let it get you concerned. We're going to get through it. It's going to be more fun than you think it will be, to the extent that you think that privacy law is fun. Maybe as I do. But there's a lot of topics. We're gonna power through them, though. I think we won't really dally on any topic in particular. What I'll say is, and I've got a QR code to the text of the law there, so you can pull that up if you want to follow along at home. And we'll have statutory references on the slides as well, so you can kind of note things along the way. What I'll say is that this law is 8 pages long. It's remarkable when you think about how long the Cpra was and is, and how much longer the Cpra, the California Privacy Rights Act, will be. And then you combine that with the fact that in California there was regulations around the Cpra. Obviously, a lot of you know we've talked about those at considerable length in our webinars. And then the Cpra is going to have 3 times as many regulations as the Cpra did. But this is it. Virginia is 8 pages, right? And there is no affirmative duty to produce regulations. There is a wrinkle, which is probably worth talking about, which is there was sort of towards the end of the progress here on the bill, there was a provision put in that there would be a study of the bill done by committee, and they would produce a report next November 1st, 2021. So there's potential for some tweaks on this bill between now and its effective date, January 1st, 2023. But point being, and to sort of put a finer point onto it, right, is we've got 8 pages, right? We don't have, 34 pages of CCPA text, CPRA text, regulations, final statement of reasons, all that type of stuff, right? So a fairly condensed bill, statute, but nonetheless, tons to unpack, as you can tell with the topics here. What I'll say before I move on to the next slide is, number 14 there, I'll talk a little bit about what's going on with other states if we have time. I think people know, if you're tracking me on LinkedIn or with our blog posts, we've been tracking all these states, right? So there's a lot to be said. Virginia is one of many states that is considered privacy legislation, the only one that's got it across the finish line right now, but other states are in play. All right, so let's dig in without any further delay. Scope is our first topic, I think for good reason. So this is the way that Virginia has set it up, right? And for those who listened to the last webinar, you'll know that Virginia is copied Washington, right? The Washington Privacy Act, and now it's the Virginia version of it. They tweaked it in many respects, but it has the same sort of setup with respect to scope, right? So this is going to be familiar to you if you've been tracking these bills. I'm going to break down CCPA, Cpra in a second, but I do want to provide you with, what we have here, right? And so there's basically two ways you get involved here. You obviously got to be conducting business in Virginia or producing products that target residents of Virginia, which is itself, barred from GDPR, right? And then you either have to, during a calendar year, control or process personal data of at least 100,000 consumers, just consumers, not households or devices, as you would see in CCPA, or what I call like the data broker category, right? You control or process 25,000 consumers' information, and you're deriving 50% of your revenue from being a data broker, essentially selling personal data. Now, a couple things to flag here is the definition of consumer, which I will show you on the next slide, is incredibly important here. The second thing I'm going to tell you on the second category with respect to data broker, the definition of sale here is narrower in Virginia than it is in CCPA. We do not have that phrase, other valuable consideration. So some things to take away. But listen, there's our scope, our baseline scope. What is really, really important and significant to keep in mind is the definition of consumer, right? Because counting matters in this scenario, right? Counting the number of consumers is going to matter for whether or not you're subject to it. So if you go back through the statute of 571 here, go to the definition of consumer, you will see this definition here. I've copied and pasted it for ease of reference. It says it does not include a natural person acting in a commercial or employment context, right? So again, it's incredibly important for B2B plays, for people who are on the cusp of that 100,000 threshold, because all things in this bill flow through consumers, right? Consumers have the rights, and they have the rights in this capacity, their individual or household context capacity. There is not, if you go through this bill, and if you're familiar with the CCPA, and you know that at the end, right before it went into effect, they added in language that it provided a B2B exemption and an employee exemption, you will not find similar language in the Virginia bill. This is where you get that to come into play, though, right? This sentence, it does not include a natural person acting in a commercial or employment context. That's it. That's where you get it, right? So if you're looking for a B2B exemption, if you're looking for an employee exemption, look no further than the definition of consumer. Got it? Okay. Process or processing is the other definition I provide to you there. I think here the significance is, again, it's 100,000, right, that individuals that you, during a calendar year, that control or process. So it's control or process the personal data of at least 100,000 consumers, right? So these concepts of control and process and processor, which we'll talk about in a second, these bleed from GDPR, right? But so this is not only the controller, like i.e. this is my data, this is also, am I the processor, am I processing this data? And so that, I think, broadens it to, in particular, like SaaS providers, right? Whether the fact that you process this data on behalf of other clients subjects you to this law as a processor, right? So that, I think that language there is going to really kind of capture some people. So I foreshadowed this before. This is the first of many charts that we will see today, and the first of many attempts to draw comparisons between this bill and the California bills, right? And some slides will actually get into GDPR a little bit as well. Here, I think the first takeaway here is that apparently every privacy law on a state level in this country needs to start with a C. CCPA, Cpra, Cdpa. What I will say is I think there's a debate in privacy law right now about whether it will be Cdpa to refer to Virginia or whether it will be the Cdpa to refer to Virginia. I'm not sure who's going to win. I've chosen Cdpa today as my standard. There was a Twitter poll done by Jed Bracey at the IAPP. He's the editorial director. Yesterday he did a Twitter poll, and 56% of people favored the Cdpa, and 44% of people favored Cdpa. So maybe that's indicative of where we're going. Anyway, I hope this deck ages okay, notwithstanding my choice of acronym. As everybody knows who talks with me on the phone, they know I always say that acronyms are incredibly important to privacy professionals. Without our acronyms, it would be like, a barber not having scissors, right? We need our acronyms in privacy law. They're very important. So anyway, sparing all of that, what we have here, and I think the big thing to point on this one, a couple of things, right, is one, there's no monetary threshold in Virginia, right? That $25 million monetary threshold in California is really what caught a lot of entities up in being subject to California. And then there is this progression to, if you kind of look top down on the consumers, you'll see there that it's gotten narrower as we've gone along in this country. Cpra, 50,000 consumers, households, or devices. Cpra bumps it to 100 grand, gets rid of devices. And now Cdpa gets to 100,000 consumers, but again, excluding, with that definition before, right, the employees and the B2B. So really kind of interesting progression there. Similar to data broker, right? Well, slightly different in the sense that Cpra adds the sharing category, which is obviously a new term in the Cpra, just to confuse everybody, right, as a new term of sharing. And then, Cdpa has this 25,000 plus. So some fluctuation here. I mean, I don't know what it is about the United States and its sort of obsession with thresholds for applicability of privacy laws. This is not something we see in GDPR. There's provisions in GDPR, like Article 30 provisions, that don't apply to small businesses, but not this sort of rigmarole about who applies to and doesn't apply to. It's kind of fascinating. It's fascinating to think that we're making decisions about the protections of data based on the size of companies, as if your data has less relevance or privacy implications at a smaller business that might be doing more with your data. But the counterpoint is, this was pointed out yesterday in hearings on the Florida bill, is the burden on small businesses, right? The burden on small businesses to be able to comply with these laws. Okay, in any respect, that's our comparison. Controller, so let's talk about this for a second, right? The Virginia law, whichever acronym we choose to use, it uses the terms controller and processor. And so people who are on this call who are familiar with GDPR are saying, yeah, Dave, no kidding, right? Of course we know it does that, right? But that's different than California, right? California uses business and service provider and third party, and now there's going to be contractor when we get to the Cpra. So here it's controller and it's processor, right? And clearly those terms are drawn from GDPR. This, again, it's derivative from the Washington law, where it was drawn directly from GDPR. So I've put up here the distinction between the language for Cdpa and GDPR. And you can see they're very similar. The differences being is in GDPR, it has this reference to public authority, agency, or other body, right? There is, when you get to the scope and you get to the exemptions, that is carved out specifically from the Virginia law. It does not apply to Virginia government entities, right? So a difference with GDPR, right? And also the phrase, I think it's like 5 or 6 lines down, it starts where the purposes and means of such processing. That's not in the definition of controller for Virginia. It's a more truncated, obviously, version, a little bit narrower version of the definition of controller than in GDPR. Processor, similar, right? You can tell exactly where they're getting the definition of processor from. And again, you see that the primary difference, the only difference between these two phrases is the deletion of public authority, agency, or other body, right? And they changed that to which, or which to that, I should say. So again, drawing directly from GDPR, right? Connecting the dots here. This section here, which I've copied and pasted, not to annoy you, but to give you something to look back on, and as a discussion point, is, okay, well, when are you a controller and when are you a processor, right? And so what they tell you in Virginia's law is they say, well, it kind of depends. It's fact specific, right? What is fascinating here, and I was talking to a client about this Tuesday, what is fascinating here, right, is as you just saw, we know they're pulling these terms from GDPR, right? There's really no debate. So over the summer, the European Data Protection Board, which is the College of Data Protection Authorities in Europe, the EEA, published guidance on the differences between controllers and processors. And it may seem clear when you're acting as a processor, it may seem clear when you're acting as a controller, but that is not always clear. And anybody who's wrestled with GDPR knows that there's difficulty there, right? And so here's what we have. We have phrases that we know are pulling from GDPR. We have this random sort of, well, it kind of depends phrase here about whether you're a controller or processor. I mean, to get to the point, right, are we not, as a privacy community, going to be looking to the European Data Protection guidance on controller processors, you know, the 30-page guidance that they issued over the summer that says when you're a controller and when you're a processor? Are we not going to be looking to that to interpret these terms? Of course we are, right? And so you see what is kind of fascinating and ultimately irrelevant for my discussion here today probably, but you see European data protection law embedded in U.S. law now. It's clear here, right? It's clear. And it's clear, I mean, you can envision a fact pattern, right, where, you know, people are in the United States are getting into, you know, enforcement proceedings and saying, no, I disagree. And I disagree on the basis that, you know, the European Data Protection Board says X, Y, and Z, right? It's kind of fascinating to see how it's going to trickle down. Anyway, okay. Exemptions, right? Another big deal that we got to talk about on the front end. If you attended the last webinar, you'll recognize these slides. I added another slide here, the next slide, to tease out some more of the exemptions. But this is what I call, you know, slide, 18 here is what I call like the ones where all my banking clients jump off the webinar. I hope that's not the case, but, you know, the exemptions here are broader, right, than CCPA and Cpra. In particular, the GLBA financial institution one, it's an entity exemption. It is what it is. I mean, it says as much. And data. I mean, it's got both the entity exemption and the data involved there. And, you know, what I'll say is that is not going to be the case with all these bills necessarily. Some bills will do entity exemptions in other states, that is. For GLBA financial institutions, some will not. During the hearing yesterday on the Florida bill, you know, the bill sponsor said they will not do entity exemptions. They feel like there's things financial institutions are doing that are outside GLBA. Again, you know, HIPAA-covered entities as well, entity-level exemptions. Well, what I'll say there is a lot of text in this bill on health information, right? And so it's really hard to kind of like just put it up on a slide that's easily digestible, right? If that's your area, look at the bill. There is a lot of information there. I put the section citation there. Take a look. Nonprofits, higher education institutions exempt, right? Not the case in the Washington version of the bill. There, it would be those entities would be staggered. They would not go into play immediately, but it would be staggered applicability. So again, here exemption, but maybe not the case for these other bills if and when they pass. New slide here from the last webinar deck that we did. You know, but more exemptions, right? This bill is just exemption heavy. FCRA data, you know, you're going to read that. It's going to be very similar to like your CCPA, Cpra exemption. And then, yeah, there is the employee independent contractor job applicant data exemption as well. We talked about that earlier, how that's done, not only through the consumer definition, but it's done here as well. But again, you know, taking a look at these, important for you to kind of read through this, right? And then, you know, Farm Credit Act one, right, is, you know, that's a data exemption. I know we have entities in the system that attend our webinars. That's not, you know, wasn't in the CCPA added to the Cpra, and here it's data. It's not an entity exemption. Okay. Personal data, the next sort of big thing to kind of chat about, right, is the definition of personal data. So there it is, the definition. This is not CCPA-like. This is not where they list every single data element out there. This is, you know, a GDPR-like definition of personal data. It's different, but it's similar to GDPR, where it does not list out by specific data elements, right? And then it has exclusions, right? And two exclusions: publicly available information and de-identified data. The publicly available information is twofold. Government records, we're familiar with that. That was in CCPA, very narrow exclusion, right? And then the second one is this made available to the public exemption. This is important to keep in mind when you're looking at these bills. This is something, and I had the third bullet point there that says virtually identical to Cpra. This is something that was not in the CCPA, that's made available to the public. It was added in the Cpra, and now it's being adopted, right? But this is one of these things when I look at these bills, I pay attention to, right? So what does this mean, right? This means if I am the business and I have a reasonable belief as the business that this information is publicly available, then it's publicly available, right? This is like LinkedIn profiles and Facebook profiles and all those types of things, right? Twitter, all those types of things. And you have organizations who make a living out of scraping data, right? And then selling that, right? And if that is outside this law, then it's outside this law. And what you also see, and this connects with a later provision in the law, which says, you know, hey, if you have received data with the belief that it's not covered, then you can't be subject to the fines, right, to the enforcement provisions. So it creates this sort of trickle-down effect of how data is still going to be publicly available data out there on the internet is still going to be excluded from this law, right? It's a big deal. And it was coming with California anyway, but we're going to see it more ingrained here in Virginia, right? This definition of publicly available. And again, it's the point of view of the business, and it's a reasonable basis to believe, right? A lot of loaded words there. A lot of loaded words there. Okay. The identified data is the other exemption. This is sort of tying in with the CCPA, right? And the definition there about the second bullet point, controllers that possess de-identified data must, and there's 3 steps there. Yeah, it's very similar to the Cpra, right? Definition of de-identified data. I think, I think almost, if not word for word, very close to the 3 steps that you see in the Cpra for de-identified data. So again, de-identifying it takes it out of the statute. It's not personal data. So the rights. Gosh, lots to unpack here, right? So this slide, these are the rights provided in Virginia, right? I'm going to do a comparison in a minute of the rights in California versus the rights in Virginia. I think some things to tease out here is, one, there is no 12-month look-back period. We've gotten very familiar in the CCPA context with the 12-month look-back period. That is not in the Virginia law. You won't find it. The other thing to tease out is the data portability concept. It applies to data that the consumer previously provided to the controller, right? Consumer previously provided to the controller, right? As opposed to other places that you would receive information from. So again, back into this idea of how businesses collect information, what's going to be subject to it, that publicly available thing we were just talking about. But this is, applies the data that the consumer previously provided to the controller. And this comes, similar to a GDPR concept, right? GDPR also is a little bit different in this regard, where that right of portability only applies to the consent or contract and with automated means. But we don't have this, we have a little bit of a concept of consent in this bill, which I'll talk about in a little bit. But sort of, I guess the point being is, right, is data portability is not everything, right? It's not everything. One other thing here to kind of tease out, you see that delete, the personal data deletion right there. If you are familiar with the CCPA and Cpra, you will know that it says, paragraph 1, you have the right to delete. And then it lists, 9 exemptions or something to the right to be forgotten in the CCPA. You will not see that in Virginia. Virginia comes about it differently, which is you get a separate section on limitations, and we'll talk about that later. So essentially, you're going to be looking in the 2 different sections of the statute to piece together the exemptions with respect to the right to be forgotten here. Okay. One other thing to foreshadow is these rights are not going to apply to synonymous data. Talk about that in a little bit. but just want to kind of tease that out because there is this concept of de-identified, which is excluded from the definition of personal data, and then there's this other concept of synonymous data, right, which is still included, but in the definition of personal data, but certain rights, like the rights here, don't apply to it, and there's other aspects like the privacy policy doesn't apply to it, which is different than GDPR, but again, it kind of creates this other category of data that's going to be treated differently. Okay. The last slide had I failed to tease it out before I moved, but it was this opt-out right? We're coming to this country is coming to privacy law with an opt-out right. We have yet, we'll see if Oklahoma changes that, we have yet to be an opt-in regime, right, for the collection of personal data. So we are really focused these days on our opt-out rights, and Virginia has 3 of these now: the opt-out of targeted advertising, sale of personal data, and profiling, and then there's a lot of language in profile we'll go over in a second. So the first one is the opt-out of sale. You're familiar with this, right? With the Cpra and Cpra, you're familiar with this. What I will say is the definition here is narrower, right? It does not include the other valuable consideration phrase that exists in the Ccpa and the Cpra, right? And then we've got our exclusions there as well. So, disclosures of processors, kind of familiar, right, with like the sort of the service provider category of disclosures under the Ccpa, products and services, controller affiliates. I think that one, that disclosure to controller's affiliate is a big one there too, right? I mean, something we really wrestle with the Ccpa. So sort of narrowing it here, no doubt about it. And then, number 4 again ties into what we're talking about publicly available, right? Is that if the consumers made it available to the general public, right? It's another way we're sort of reinforcing the same concepts. Opted out of target advertising. So, last webinar we did, I sort of talked about this one, right? Is this concept of targeted advertising is going to be fascinating to tease out, I think, over the next couple of years. I mean, what is targeted advertising? We're talking about cookies, right? Third-party tracking cookies, more specifically. And for those of you who follow the news, Google is phasing that out. They're going to be sandboxing and doing, I think the acronym they're using is FLOC. So it's changing. I mean, it's fundamentally changing, but you have this concept here of targeted advertising, opting out of targeted advertising, which is really, again, what we're talking about here. And so where we're at in 2 years on this kind of remains to be seen. I think as well, though, is, we've been talking about targeted advertising, at least in the cookie context, through the prism of sale under the Cpra, right? And now we have a separate targeted advertising definition and concept here. So, you see this sort of tension between California and Virginia, and how what is called something in one state is going to be called something different in another state. And we're going to have to spend some time really kind of teasing this out with the overlay of, new technologies coming into play and trying to figure this out at the same time. Opt out of profiling. This is a specific type of profiling. That's that second sentence there, has to be in furtherance of decisions that produce legal or similarly significant effects concerning the consumer, right? And I've got those definitions there. Okay. So I talked about this a touch before. There is an exception to, not exception is not the right word to it, right? There's a caveat to Virginia being an opt-out regime, which is sensitive data. So the collection of sensitive data will require consent. And, we've talked a lot about exclusions. We've talked about how, Virginia may be a more business-friendly state than California's bill and other bills that are getting proposed. But this is the provision that privacy advocates will point to and say, listen, it's stronger, right? And they're right. I mean, this is, in fairness, this is a step beyond what California is doing. And I'll show you California in a second. You're going to need consent to process this, right? And I'll show you the definition of consent in a minute as well. But these are the elements. This is, you're looking at this, right, and you're saying, well, this kind of looks familiar, right? It's similar to GDPR Article 9. It's not the same. Article 9 GDPR includes political opinions, philosophical beliefs, and trade union membership, and it does not include 5, citizenship or immigration data, and does not include 7, personal data of a known child. Obviously, GDPR comes about that differently, right? So similar, but different, but obviously drawing again from GDPR on this, right? Now, GDPR is, the consent mechanism there is explicit consent. That's not what it is in Virginia. It's just consent. But you're going to need consent to collect this information. I know this before, right? The Cpra is also dealing with sensitive personal information, but it comes about it differently. It's still an opt-out methodology, right? It's the right, and this is new. It's new in the Cpra, which will go into effect at the same time as this bill will, January 1st, 2023. So this new category of sensitive PI is being created under California law. It doesn't exist in the CCPA. It's being created. But there it's this right to limit use of sensitive personal information, right? So there's a lot of words on there. Let me try to parse through it. It's essentially like, as a business, you can collect it. It's fine. And you can actually use it for specific purposes, right? But if you stray into other purposes, then a consumer is going to have the right to limit your use back down to those purposes, right? So obviously a different way of coming about it. This is the definition of sensitive personal information under California law. Again, another tension. I think you're sensing it, right? There's a lot of tensions between California and Virginia here. The definition is broader in California, I think, is fair to say. You have mail content, right? So the content of the consumer's mail, email, and text messages, and then ID numbers and financial account information. Financial account information is not subject to Article 9 GDPR. There's kind of a difference already with the way CCPA is coming, or Cpra is coming about it. But here again, you see, just depending on where you are in the country, it's going to really kind of play out differently about what your data categorization is. And this gets back to sort of first principles, right? Which is you're going to need to know what data is coming into the company, and you're going to need to be able to understand the significance of that data in various locations, right? California and Virginia, and if we get more statutes, then we're going to have to figure that out as well, because people are going to have different rights regarding different data based upon where they are in the country, and you're going to need consent in some places, you're going to opt out in other places, and it's even confusing in the sense that even if you got consent for everything, you only get consent for those things covered by Virginia. You take it a little bit further with California. There's going to be some business decisions to be made here. Okay. Incompatible unnecessary purposes. So this is the other thing that the Virginia law, Cdpa, requires consent for, which is the processing of personal data for purposes that are neither reasonably necessary to nor compatible with the disclosed purposes for which such personal data is processed as disclosed to the consumer, right? So if, hey, I have a privacy policy, it tells you we're going to do X, Y, and Z with your data, we go a step further and do something different, yeah, we got to get your consent, right? We're going beyond the incompatible and unnecessary purpose. Cpra there is notice, right? A similar type provision, but this is notice, it's not consent. So those are the two bases, sensitive data and this sort of what I'm calling incompatible unnecessary purposes that is embedded here, right, in the Virginia law. I told you before I give you the definition of consent, in fairness, I hate this slide. This is way too much text for a slide, and I sat there thinking about, well, gosh, how could I limit this, right, or make sense of this? And my ultimate conclusion was, well, who cares, right? The point of this slide is not to sit there and to line item by line item the definition of consent in Virginia versus the definition of consent in California. The point of this is basically to say, wow, California says a lot more, right? And so that's sort of the takeaway here, right, is, I think Virginia, in fairness, is, these references to freely given, specific, informed, unambiguous, yeah, right? It's GDPR, right? And then it goes on there. And then California's just got the same freely given, specific, informed, unambiguous, again, things which we're very familiar with, and it just says a lot more, right? So again, this slide is not to like annoy you by having just a lot of words on the slide. I think the takeaway here is there's tension. There's tension, there's differences here, something we're going to have to kind of dig into, right? But again, you know, consent is more limited in California to limited things, and in Virginia, it's different, right? And I'll tell you what, if Oklahoma passes, it's going to be a whole different definition in the Oklahoma bill as well. So some stuff to work through, for sure. We talked about this one as well, and you know, I try to just kind of put together a chart, right? Cdpa versus Cpra. So this is the newer version of the California law, which is, I think, in fairness, I think, you know, doing this because these ones will go into effect at the same time, right? And so you see overlap, and you also see differences, right? So confirmed processing, that's something that's really a Virginia thing, right? The right to know, I mean, what I'm getting after there is, like, if you look at the Cppa and the Cpra, it's got this, hey, you can make a request to understand categories and third parties and all those things. You're not going to find that in Virginia law, right? Those types of requests. It's probably a good thing. I don't know that that's really been something that's brought value to privacy law, but, you know, it doesn't exist in the Virginia law at all. Then you see a lot of things that are the same, but then you start seeing differences in this. Obviously, the consent to collect sensitive personal information, we talked about that, the limit the use of sensitive PI, you get that now. And then these opt-out differences, right? In California, it's opt-out of selling and sharing, and then in Virginia, it's these targeted advertising, sale, personal data, and differences there as well. One thing I'll note is I think one of the questions came in, I may have misspoken on the original slide on the employee exemption issue, not finding similar language. There is that, in fact, that employee exemption. I teased that out in the last slide, so apologies if I misstated that in the opening slides, but there is that employee exemption language. Thank you for that question there, that clarification. Apologies again if I misstated that. Okay, so other differences, right, that I'm sort of seeing in this bill as you go through it. The Cpra has the storage limitation principle. So you have to be talking about that in your privacy policies in particular. Cpra requires disclosures around the use of automated decision-making technology, just more advanced in that regard. And then you see similarity, though, in data minimization requirements there. Okay, consumer requests, similar but different, right? So 45 days to respond. You can get another 45 days if you provide prior notice. Authentication, you know, you don't have to respond if you can't authenticate the request. I'll talk about that in a second. Free of charge, you know, unless it's manifesting unfounded. Again, you know, similar concepts, right? These are things I think you're familiar with. Parent or legal guardian can submit a request on behalf of the child as well. Tease that out. If you decline a request, right? You got to do it within the first 45 days and notify the consumer on the basis for it. And this is where we start getting divergence with California, and again, tension here. So say you deny a request, right? You have to provide an appeal procedure under the law, and you've got to make that conspicuously available. That's got to be similar to the way you submit requests, and then you've got to process that within 60 days. And if you deny it, you got to tell the consumer, hey, here's the contact information, rather, for the Virginia Attorney General's office, just in case you want to go complain, right? So a difference there. I mean, I've read a lot on this, and people have said, you know, this is really going to throw a wrinkle into like automated processing that some companies have done. I don't know. I haven't thought that all through quite yet, but certainly a distinction between Virginia and California, right? Some other differences, right? I think you sense a theme here. There are differences between these, right? Virginia doesn't require the toll-free telephone number. Gosh, that was a big deal back in the day. I mean, it feels irrelevant, not irrelevant, but like, you know, that it was a big deal, right? I mean, like privacy advocates fought over the toll-free telephone number in the Ccpa. It's not there. It's not in the Virginia law. There's also not, and this is big. I don't want this to go unnoticed. Is, you know, in California, if you're selling, you've got to have a link in your website footer that says, "Do not sell my personal information" today, right? That's not Virginia, right? And so Virginia has these opt-out rights, but they're not as in your face as in California, right? It's not this sort of like California approach of, I want to dominate your website with all these types of things in your website footer, right? It's really under the radar, and it's subtle, but it's significant. I think it's significant there, right? And then the third one, the recognizing opt-out preference signals, that's a big one too. If we haven't talked, if you're a client out there and we haven't talked about global privacy controls, give me a ring. We can talk about what the Attorney General is saying on those things and how to approach them. That's something that privacy advocates have said they want to try to get into the Virginia bill before it goes into effect, right? Okay. Cdpa, the methods of receiving requests, one or more secure and reliable means. And again, right, we're not going to have, and it's the next bullet point there, we're not going to have these regulations, right? You're not going to have, be sitting there with 20 pages of methods of receiving requests and verifying requests. It's not, I suppose somebody could say the Attorney General's office could still publish guidance on these issues, but it's not like it is in the California law where it says it has to happen, right? And so it's a big distinction here, and it's much more similar to sort of GDPR. And I think, what I kind of had in my mind there is, the ICO, not sort of GDPR, but certainly was at the time, but they were pushing out tons of guidance right on their website, right? So if you needed to know kind of how something worked, you go to the ICO's website, you get some guidance on it, you feel like you're doing it right, right? I can envision something similar in Virginia. It's not regulations, but it's, website guidance types of things on these issues. But we will not see, I don't see anywhere in the statute for a basis for it, this process that we're going to go through in California that we went through in the past, and oh my gosh, we're about to go through it even worse with 3 times the regulations over the next year, right, with the Cpra. Okay, no authorized agent or household requests. I think the authorized agent one is something that privacy advocates are going to try to get into the bill. We'll see what happens in the next legislative session before the bill goes into effect. Privacy policy, shocking. You're going to have to make privacy policy disclosures. I know. I mean, this is like the least surprising portion of my discussion today. Probably the thing you anticipated the most. There it is. Those are the 6 things that you need to be talking about in your privacy policy. My guess is you are going to be extremely familiar with these concepts, and I am not going to dilly-dally on a slide that we all anticipated and knew was going to be there. Okay. I talked about this before, synonymous data. Gosh, I hope I'm saying that right. I'm probably butchering that name, that term, I should say. This is not subject to the privacy rights, and it's not subject to the privacy policy requirements. Now, it is subject to the data protection assessments, which it happens to be the next slide, which is why I put this here. But this type of data set here, it's covered, right? It's not outside the definition of personal data. It's just that certain aspects of the law don't apply to it, right? And there you see, I've kind of highlighted what I thought was the important thing to kind of drill this home. It's personal data that cannot be attributed to a specific natural person without the use of additional information, right? That's sort of, it's a data set, but you need, another piece of information to link it to, right? I mean, like, if you go online and try to find, this is like pen names and those types of things, right? Yeah, anyway. I think you guys get it. I say as well, though, is, to try to tease out some of these, GDPR, CCPA types of things. GDPR recognizes this, right? So it's not a new concept to us. The way GDPR comes about it, though, is like this is a technical and organizational measure, right? So this pops up in like Article 32 of GDPR, right? Encryption and synonymous data, right, as technical organizational measures. Still subject to GDPR, but as a way to get your technical and organizational information security measures. CCPA, Cpra, last night I went through, I got curious about how this pops up there. Unique pseudonym is in the definition of unique personal identifier. So really not something in play with CCPA, Cpra. Okay, I mentioned this before, data protection assessments. First thing to note is this is not a typo. It is data protection assessments. That is the phrase they're using. I know you guys out there who are familiar with GDPR are saying you're missing impact. I'm not. This is what it is. We will be calling these DPAs, not DPIAs, which will, of course, confuse everybody when we talk about data processing agreements, but we are, again, very beholden to our acronyms in privacy law, so it sort of is what it is. So let's talk about them then. What are they? That'll be the next slide. The first slide is when are they required, these data protection assessments? They're required 5 times. Targeted advertising, sale of personal data, processing of sensitive data. We've talked about all these things so far, right? Certain types of profiling, I've got in the small print there, the types of profiling that will trigger these types of things. Different than the profiling that we talked about opting out with respect to, right? There are differences and subtleties in the profiling under this law. But point being, you know, it's one of those times you're going to have to do a data protection assessment. And then this general, you know, processing activities that present a heightened risk of harm to consumers. Good luck with that one. I'm sure we'll think that through a lot. But that's not a foreign concept, right? It's something that we've kind of wrestled with in the past. And again, you know, anonymous data, still got to do it, right? Because it's not outside this. Okay, so what are the requirements, right? Not a lot in the law here. And this would be, you know, to the extent that there was some sort of like website guidance or something along those lines, this would be something that would be potentially, you know, ripe for that. Again, as distinguished from like regulations, right, which is not affirmatively required in the statute. The concepts here, though, are fairly basic. You got to weigh the risks and the benefits to consumers, get safeguards to reduce those risks, right? A balancing act there. And then, you know, you can consider the use of de-identified data and the reasonable expectations of consumers within the context, right? I mean, this is basically just driving after a holistic approach to why are you collecting it? What is the point of the collection? What type of data is being collected? Do you need to collect this data, right? What is the impact to the consumer? What's the risk to the consumer? What happens if you lose this data, right? All those types of things, right? That's all going to go into these data protection assessments. Good news, I suppose, is it's only going to apply to processing activities created or generated after January 1, 2023. But that's kind of ripe for interpretation, I suppose. And I think there's going to be a lot of, you know, hard discussions within businesses about when that comes into play and when it does. And I'm sure there's going to be, you know, very easy examples on that point. What I find fascinating is this next provision, which it says the disclosure of these data protection assessments pursuant to a request for the Attorney General's office shall not constitute a waiver of attorney-client privilege or work product protection, right? I'll be honest, the first time I read this, I just glossed over it, right? Fine, you know, whatever, doesn't waive attorney-client privilege and work product. Then when you think about it a little bit more, what you realize is what they're telling you is that you can do this under attorney-client privilege and work product, right? Because if disclosing it to the AG's office in response to a request doesn't waive it, then that means that it actually can be done under that privilege, right, and under work product. So this is significant, I think, for the way that this will play out, right, is to be looking at these processing activities, these 5 types of processing activities, target advertising, sale processing, sensitive data, all those things, because you're going to be doing that within the context of, you know, well, potentially, right, legal counsel, right, who's going to be advising you as to what the law says and, you know, risk profiles with respect to doing this stuff, right, because the DPA doesn't say, like, you don't have to do it, stop, full stop. It says you have to analyze it, right? Take these things into account and make these determinations. And I read this to basically be saying you can do it under privilege, right? And that, I think, is a big deal. I think that's a big deal to companies. But you're probably saying that's because I'm a lawyer. Yes, that's right. That's right. In full disclosure, I am a lawyer. Okay, so this slide is sort of the, again, like the tension slide, right? And so this is basically how does GDPR and how does Cpra come about it, right? Again, GDPR has a different acronym, DPIA here, likely, but again, this high risk to the rights and freedoms, and there's 3 specific times it's required. I didn't list those out. I figure people who need to do them are familiar with them. Cpra is going to be different, right? They have this concept of risk assessment. They're going to be required to submit it to the agency, and what I'll say here is, though, is this is one of these things that's going to be a topic of regulation that we're going to start seeing come out of California. So a lot to be determined here, but I really just wanted to kind of tease out, if you're, depending on where you're at and what jurisdictions you're subject to, what laws you're subject to, things might be a lot different, right? Okay, data processing agreements are the contracts, right? 1 through 10, went through the statute, listed it out. What I will say to you is it looks a lot like Article 28 GDPR, right? There's differences. There are. I think number 9 is a difference there, which is, you either need to allow for the assessments, or you can arrange for a third party to do them. That's different, right? But these concepts of having contracts in place for the transfer of data is, it was obviously it's in Article 28, and many companies have been wrestling with that for 2 years now. What I'll also say is, we went over this extensively in a webinar. Gosh, I can't remember. It was two webinars ago. Malia and I were doing it on California, the Cpra, and we really went over extensively over how that's going to really change the data processing agreements. And we have, I think it'll be this month, we have an article coming out in IAPP as well that goes over the contractual requirements in California. So I guess the point of all that is to tell you that one of the things that you will be spending time thinking about between now and January 1st, 2023 is all your third-party transfers and getting that buttoned up and having DPAs. If you have a DPA already, because of GDPR, CCPA, maybe you've been doing service provider DPAs, you're going to have to change them. If you don't have them already, yeah, congrats, you've dodged it this long. But if you're subject to these laws, it's coming. And what I'll say is too is that is not something that you can wait until December 2022 to get accomplished, right? That is something that you need to start thinking about now. It's going to take time and energy to do. And also, not to make life more complicated, but if you are in Europe and you're dealing with that, there's also the fact that the European Commission is got draft, Article 28, standard contractual clauses, drafts now. If you're there, you know what I'm talking about already. But point being is, like, there's a lot going on in this space, this contracting space right now. It's going to be a lot to get our heads wrapped around. Okay, processor duties. So this is, you're sitting in the chair of the processor as opposed to the controller. What are your duties with respect to that? Here they are, not complicated. You got to assist the controller with consumer requests. And I think, too, what's kind of important to point out, right, is that if you know GDPR has many more responsibilities for controllers than it does processors, right? It is very much looked at the prism of controllers versus processors. That is consistent with Virginia, right? I can't say it's a one-to-one. Obviously, there's differences, but that's consistent with Virginia, where it's a focus on controllers, and then processors are secondary, right? And so you see that here, right? With the processor's duties, you got to assist with consumer requests, assist with the information security measures, provide information for the data protection assessments, right? And again, this is all through the prism as well with the prior slide that I showed you, which is the fact that you are going to have a contract, and that contract is going to say you have to do a bunch of things if you're a processor, right? Okay. Financial incentives, I think I will call this next slide my least favorite slide in the entire one. It was close between this slide and that slide I showed you on consent, which had all the language there. This is kind of similar. I actually, last night I deleted these two slides, and then I added them back in, and I deleted them again, and I added them back in. My feeling here was, I'll just give it to you. Similar sort of concepts as the CCPA with the financial incentive loyalty rewards program. If it's significant to you, you've got it in the deck. Gosh, that's really all I want to say about this one here, right? We can just sort of move on. But if it's significant to you, again, it's there, and you can read and dig into it. Limitations. I talked about this before when I was talking about the rights, right? So you read the entire statute and then you get to the limitations, and gosh, I said what the statute's like 8 pages long. I feel like the limitations is like 1.5 pages of that, right? Which kind of maybe tells you a lot about this law. And so, some of the limitations we've teased out here. The law does not restrict your ability to comply with law, which is always nice. You don't have to violate law by complying with law. cooperate with law enforcement, pursue or defend legal claims. We know these, right? Provide a product or service, perform a contract with the consumer. These are really just not, I think, things that are really notable and similar to like Cpra, Cpra, right? Except they just goes about it differently. And then some of the other things, right? Fulfill a warranty. This is one of those sort of like things that got thrown into the Cpra at the last minute. Was like, well, hey, what about like product recalls and warranties and stuff like that, right? Should we really need to delete personal data for that, right? And so you see that come here as well. The protect life or physical safety one is good, right? Especially in the context of like that sensitive data category, right? Is you don't want to get into a situation where, you know, before you provide life-saving emergency services, you need to obtain consent for something, right? And yeah, I mean, and again, give that example, but I pause that by saying again, there's lots of exemptions for health information anyway in this law, which we talked about at the beginning. But this sort of concept of, and you see it in GDPR as well, this concept of, you know, these privacy laws really, you know, need to be practical to a certain extent and not get in the way of doing things like saving people's lives, right? Prevent security incidents, fraud, you guys get that. Engage in certain types of research. If research is your thing, you'll want to dig into this law and take a look at it. It's got a lot to say on those issues. This is, so the prior slide, this may be subtle, but the prior slide said law does not restrict ability to, right? This slide says law does not restrict ability to collect, use, or retain data to, right? And so this is the way it's broken down. Literally, statute breaks it down into two different sections. This is, you know, the slide on it doesn't restrict your ability to collect, use, or retain data, right? Internal research, effective product recall, I talked about that before. Repair technical errors, yeah, you get that. But number 4, look at 4. Like, look at the fourth one down there with the two individuals shaking hands, for lack of a better symbol down there. Doesn't restrict your ability to perform internal operations reasonably aligned with the consumer expectations, reasonably anticipated based on relationship or compatible with the processing related to product purchase or service. Man, that's a loaded phrase, right? Right? I mean, and this is with respect to like your ability to collect, use, or retain data, right? So think about this in the context of consent. Think about this in the, for sensitive personal information. Think about this in the context of deletion, the right to be forgotten. A really interesting turn of phrase. I think something that we will be focusing a lot on. I think it's intentional that it's in there, obviously. It's intentional that it's in there in this bill, but really something I think that could potentially be a big gaping hole here. Okay, enforcement. No prior right of action. Up front, no prior right of action. AG enforcement, you guys know this, right? What's interesting is it's the current Cpra model, right, which is like notice and 30 days to cure. That's deleted. The 30 days to cure is deleted in the Cpra, but it's in the Cpra, and we're going through that process. Now, damages, $7,500, slightly different than the Cpra way of going about it. And then, you know, there is this consumer privacy fund. Don't want to kind of skirt that issue, which, you know, this money will go into the consumer privacy fund because something to keep in mind, there was a roll call report out right when this law went into effect, and they said, well, you know, how much money will be devoted to enforcement? And the AG's office said something like, you know, $400,000 or something like that, right? But if they have a fund that kind of like is used to fund these enforcement activities, that becomes a little different. No DPA, which is different than California, big deal there. And then just no statutory damage to data breaches. We're not going to see this, you know, $100 to $750 per consumer per incident thing. We're at 11, so let me just take you to the last two slides quickly, be respectful of your time. Effective date, January 1st, 2023, we talked a lot about that. And I just put on this slide all the California Privacy Rights Act deadlines, so you had that for context. I had this other states. What I'll say here is, you know, we're tracking this, right? So if you've got these slides, you know, go to our privacy law tracker. We're staying on top of all these laws, and we're pushing out content when it's important, when it passes the House or obviously becomes law itself. I always call this, and this will be the you know, conclusion of my remarks today, I always call this my shameless plug slide, which is we have a blog. And if you're not subscribed to the blog, you should be, right? So we got a QR code there, and I think there's something at the end as well that allows you to go on to the, just put your email address in or something like that, and you'll become subscribed to the blog. If you're not, you really should be. I really do encourage it. It's an easy way for us to keep talking to you guys in between webinars. We're up on LinkedIn. We've got previous webinars as well. A lot of bells and whistles for you guys. I'm a minute late, and I want to be respectful of everybody's time, so what I'll tell you is thank you. Appreciate you guys jumping on here today, and look forward to talking with you guys the next time as well. Thanks.